Hi, good afternoon. Welcome to UC Hastings College of the Law. My name is Emily Goldberg-Knox, and I'm the editor-in-chief of the Hastings Law Journal, a co-sponsor of this symposium. I'd like to thank all of you for being here, especially our esteemed panelists who have traveled from across the country to be here today. I'd also like to thank Professor Scott Dodson and Professor Stephen Sachs for inspiring this symposium, among others who are here today, and all of the members of the Hastings Law Journal for their hard work in putting this symposium together, especially Rob Taboda and the entire symposium staff. Also, a thank you to Roz Foy and the Academic Dean's Office for their help with this. A big thank you also to our sponsors for their generosity and support: Baker Botts, Davis Polk, GJEL Accident Attorneys, Curran Wagstaff, and Kirkland & Ellis. Finally, I have the pleasure of introducing Hastings' own Roel Schiller, Professor of Law and Associate Dean for Research here at Hastings. Dean Schiller, a graduate of the University of Virginia School of Law, focuses on 20th century American legal history, administrative law, and labor and employment law. He is currently working on a book about the interaction between the legal strategies of the labor movement and the civil rights movement in the years after the Second World War. Without further ado, please welcome Dean Schiller.
Hi. Thank you, Emily. So as Associate Dean for Research here at Hastings, I have the pleasure of welcoming you all to the symposium today, and I do so on behalf of our Chancellor and Dean, Frank Wu, and of course I do so on behalf of the entire UC Hastings community. I was, of course, delighted when Scott invited me here to make these opening remarks. But I have to say, when I actually saw the final program, I panicked. Because Scott, it seemed, had subjected me to what I would characterize as a bait and switch, right? You know, I thought I would be up here to give a minute or two of welcoming remarks. Instead, I look at the program, and it's a 15-minute address. That's like first year Civ Pro all over again. It's like Pennoyer versus Neff, like state the case. And sort of looking around the room at the collection of civil procedure scholars that we have here, I cannot think of anyone less qualified than me to make remarks here. Right? Brief remarks, yes. A welcoming address, no. I do teach procedure here at Hastings, as you heard, but it's administrative procedure. So perhaps the panelists will forgive me if I take a cue from my own discipline and keep my remarks streamlined and efficient, understanding that those of you who study the august federal rules of civil procedure rather than the scrappy Administrative Procedure Act may find me to be overly casual, unprincipled, and slipshod in my remarks. By hosting this symposium, UC Hastings is continuing its leadership as a center of scholarship and teaching about civil procedure. Right? As all of you know, UC Hastings has a long history as the home of leaders in this field and a center for scholarship on this subject. On this panel, we have Mary Kay Kane, we have Rick Marcus. I would also recognize Jeff Hazard and Bill Schwarzer, scholars of federal civil procedure who make their home here at Hastings. David Levine, who studies California civil procedure. I see Jim Wagstaff there also on that area. We have, with the recent additions of talented younger scholars like Scott and like Morris Ratner, Hastings is keeping up this extraordinary tradition of exacting, incisive scholarship regarding the procedural framework that holds together the American system of civil litigation, a system that promotes some of our society's most basic values: access to justice and rule of law. Whether the Atlantic Marine case furthers those values or whether it hobbles them, I take that to be the fundamental question of this symposium. And it's a question that I will let the panelists answer, and answer for the benefit of all of us. So welcome to the panelists, welcome to the audience, and please enjoy this fascinating symposium. Thank you.
Thank you, Rule. I'm Mary Kay Kane, and I'd like to add my welcome to all of you to this very important symposium on the Atlantic Marine case. The Atlantic Marine case, as I expect all of you, if you bothered to show up here, you probably know what it's about, so I won't go into detail, but let me just put us all on the same plane. What we're going to be examining is the fact that the Supreme Court made a choice. They made a choice in how do you deal with forum selection agreements when one of the parties decides to file suit elsewhere, and what is the procedure for doing so, in which they, in Atlantic Marine, opted for transfer under 1404A, rather than the couple of other procedures that were at issue in that case, as well as, once you do so, how does that affect the whole governing law question in terms of the validity of the agreement as well as the underlying dispute. And so today we have two panels, and they're going to explore both sides of that question. And so we're very excited to have some really renowned people here today to share with us their insights and to make us think a little bit more deeply about what the court said, maybe more deeply than the court thought, about some of these issues, according to the panelists. So the way this, my first panel, which I will moderate, is going to proceed is as follows. The panel is got a discussion going for 90 minutes. Each panelist is going to speak for approximately 15 minutes, which will leave 25 minutes for questions and comments. While I'll start with some from the panelists who may want to say something about each other, we have a microphone, and I'll remind you about it, and I would really encourage audience members who have questions or comments that they want to make about some of the things they've heard today or things that they didn't hear that they wish they heard about today, if you'd like to put in your comments. I'm going to introduce the panelists at the outset in the order in which they're going to present their papers, and then they're going to take over. So note that the program itself lists bios, short, given the incredible array of things that could be said about our panelists, but short bios on each of the panelists, and I hope that you will take the opportunity to look at them. But I'm going to be even more brief so that I can leave the maximum opportunity for all of you and myself to hear from our panelists as well as to perhaps engage them in some discussion about this cases. The one thing I can say unreservedly is that we have a stellar group of civil procedure gurus who are widely published and highly respected in the field. So we have a lot to look forward to today. And with that as a note, I would suggest that we will get started, at least with the first panel in this afternoon's discussion. The first panelist who will speak is Professor Bradley Shannon, and he is from the Florida Coastal School of Law. A graduate of the University of Washington School of Law, Professor Shannon clerked for several years on the Federal District Court in the Eastern District of Washington, and then he was a commercial litigator in Seattle before starting teaching at the University of Idaho and moving to Florida Coastal in 2004. Professor Shannon will share with us his view that the scheme that Atlantic Marine adopted to enforce a contract forum selection clause when one of the parties brings an action in a different court, that is transfer under 1404A, was not the optimal approach. Indeed, it was a misuse, in his view, of the transfer statute and creates unnecessary complications. And he will offer his own suggestion of a superior alternative, a motion to dismiss under the parties' contract. The second speaker will be Professor Scott Dodson, who is the Harry and Lillian Hastings Research Chair at UC Hastings. A graduate of Duke Law School, Professor Dodson clerked for the Federal District Court in Brooklyn, practiced law in Houston, Texas for a year, and then was an attorney for the U.S. Commerce Department and in private practice in Washington, D.C., before entering teaching at the University of Arkansas, Fayetteville, then moving to William and Mary Law School, and finally, thank heavens, finding his true home here at Hastings a couple of years ago. Professor Dodson will argue that the court's holding that a pre-litigation forum selection contract does not make an otherwise proper venue an improper venue, that conclusion was correct, largely because party preference cannot subordinate legal directives. And he will explore for us how, if the court remains true to that principle, it may affect the future of party preference beyond venue selection. Our third speaker will be Professor Robin Effron from the Brooklyn Law School in New York, where she is the co-director for the Dennis J. Block Center for the Study of International Business Law. A graduate of NYU Law School, Professor Effron clerked on the Federal District Court in the Eastern District of New York, on the Southern District of New York, and then was a Bigelow Fellow and lecturer at the University of Chicago before joining the Brooklyn faculty. Professor Effron will explore the potential impact of the Atlantic Marine opinion on the otherwise stable doctrine of forum nonconveniens, noting that the court conflated transfer with forum non, and as a result, raised several problems for the application of forum non in what one might call the law of unintended consequences. And our last speaker will be Professor Stephen Sachs from Duke University School of Law. A graduate of Yale Law School, Professor Sachs clerked on the DC Circuit and for Chief Justice John Roberts on the US Supreme Court. And then he practiced for a year in Washington before joining the Duke faculty in 2011. He also wrote an amicus brief for Atlantic Marine, urging a different procedure be adopted for considering forum selection clauses, namely Rule 12b6 motions. Professor Sachs will conclude this panel's presentation by examining 5 important questions involving the enforcement of forum selection clauses that were left unanswered by Atlantic Marine and that the lower courts now are unfortunately going to have to confront. So with that, sort of giving you the landscape that's here, we will start off with Professor Sachs. Go. You can either, the panelists can either sit down or stand up, whichever is their preference in speaking.
I'm going to sit down. This, I don't know if this is on. It should be on for me. Well, I'll try to speak up anyway. Yeah, I'm Bradley Shannon. I'm going to speak about enforcing forum selection clauses. But since I get to go first, I'm going to do some quick thank yous. And I'll first of all thanks to the conference organizers, especially Professor Dodson and Professor Sachs for putting this all together. And thank you second to Hastings for just doing an excellent job of hosting the whole event, and for our moderators. And thanks to the Law Journal, last but not least, for all your hard work, which is just now going to be beginning, unfortunately for you. But no, this is an excellent symposium, and kind of the theme of my essay is I don't really agree with or disagree with the court's judgment, the result so much. I think the court eventually got to essentially the right result, but mine has more to do with the methodology and how they are enforcing forum selection clauses. And I kind of have 5 kind of points or arguments, but the main one is this, I do not understand why they use, I mean I do and I don't, why they use venue transfer statutes to enforce a forum selection clause in federal court. I understand that forum selection clauses have to do with geography and venue has something to do with geography, but aside from that, if you look at the text of the statute, the federal venue statutes, the purpose of those statutes, the intent behind the statutes, any theory you want to use, they just do not seem to have anything to do whatsoever with forum selection clauses. And in fact, when I think about the whole point, the purpose behind forum selection clauses, it seems like a big part of that is to take the whole issue of venue off the table. And yet the Supreme Court, the first question in their analysis is whether venue is proper in the forum without regard to the forum selection clause. That just seems a little odd to me. And when you start further considering all the different scenarios that might come up, like whether venue is proper in the forum or improper, whether it's proper or improper in the potential transfer forum, it leads to some very odd results. And I'll just throw out one. If venue is improper in the forum that's specified in the clause, I'm really not sure what happens, because then it would not be a venue that could be transferred to. And I don't know what happens at that point. I'd be interested in some thoughts on that. So it just leads to really odd results if you try to use the statute. Point number 2 is, even if the court is right in using these venue transfer statutes, it has led to a very, very complicated scheme. because if you use the statutes, you have the normal venue transfer analysis, but then the court modifies it if there's a forum selection clause. But of course, if venue is improper, then you go a different angle. Oh, closer. Oh, sorry. Oh, okay. Okay. Yes, anyway, so if venue is proper, you use one analysis. If it's improper, you use a different analysis. If the clause points to a foreign court or a state court, you use forum non-conveniens. It's just a very convoluted thing. It was almost like I wish the court would have included a flow chart with its opinion. That would have been really helpful. And I'm just afraid that if the multi-state bar people get a hold of this, I can't imagine the sort of exam question you could spin off of all this analysis. Now, being complicated, I don't think that per se means that the court's approach was incorrect, but certainly if there is an alternative, I would be interested in hearing about that. Point number 3 is, and this one might be the most important point, and that is the venue transfer statutes were designed for one purpose, and because of that, they have a set of factors that are consistent with that purpose. But forum selection clauses have a little bit different purpose, and of course, because of that, the court had to modify the analysis. But I'm not sure if even the modified analysis is asking all the right questions that you should ask in deciding whether or not to enforce a forum selection clause. Now, I suppose the court could further tinker what it's already tinkered with. But again, at some point, that seems to me to point towards the need for a whole different procedure, rather than trying to build on something that really doesn't fit to begin with. Point number 4. Unfortunately, the court did not try to reconcile its case law in this area. The court has had several forum selection clause cases over the past couple of decades. There's several different lines of analysis. There's competing tests. And the court has yet to reconcile all of its various tests, depending on the nature of the case. And I do not understand why the nature of the case should dictate the test. I understand that every case turns on its facts, and that the analysis is going to be a little bit different in every case, but it seems like there ought to be one case across all federal cases, one test, as far as how to enforce a forum selection clause. And I guess my last point is, and this kind of relates to what I would call more the vertical, I don't know if that's the right word, as opposed to the horizontal uniformity. By using federal venue transfer statutes to enforce these clauses in federal court, they've just eliminated the possibility that state courts could use the same analysis or the same test. Because, of course, those statutes do not apply in state court. And again, I don't see why there should be a different test in state courts for enforcing. There are some differences. You normally cannot transfer a case from one state court to another. But aside from that, it seems like everybody ought to be using roughly the same test. I mean, not that states couldn't vary it, but the consideration should be pretty uniform. So what's the solution to all this? Well, my solution is I just think the court needs to just get out of the business of using federal venue transfer statutes and simply just use a basic motion to dismiss for enforcement of the clause. The idea being, if subject matter jurisdiction is improper, you move to dismiss for lack of subject matter jurisdiction. If one of the parties has violated the forum selection clause, move to dismiss for enforcement of the clause. It just seems pretty simple to me. And the beauty of this, if you had a motion that was dedicated just to forum selection clauses, you could, well, first of all, it could be applicable across all cases in all courts, regardless of the subject matter, regardless of the basis for subject matter jurisdiction. And it would adequately capture, you could tailor it specifically to the problem of forum selection clauses. You wouldn't be bastardizing a practice that was formed for dealing with venue transfer. You could make it so that it considered exactly the sort of things that you would want to consider in this situation. And the other beauty of it would be it would solve basically all the problems I've just identified with the Atlantic Marine and that approach. It would be much simpler. It would have the possibility of applying to state courts as well as federal courts across all federal cases. And it would allow the venue transfer statutes to kind of go back to their original purpose. We would have one set of analysis for that problem and then a different separate line of analysis for forum selection clauses. That's it.
Okay.
Okay. All right, so thank you guys all for being here. I'm really delighted to be a part of this illustrious group of panelists here talking about this really important topic. I'll tell you that earlier this week I asked my 1Ls, a lot of whom I see here, whether anyone had ever agreed to a forum selection clause, and one hand went up. So then we had a little talk about that, and so I'd like to try that little exercise again, since I see some of you here. Who has ever agreed to a forum selection clause? Ah, yes, okay. So I think now we have an idea of the importance and the ubiquity of the topic here today. So I'm going to focus on Atlantic Marine and the enforceability of forum selection clauses through a lens of what I've called party subordinates. So let me first begin with what I mean by party subordinates and its inverse, party dominance. So there's a number of ways to view the hierarchy of power between parties, the law, and the courts. One possible view, which is the model of party dominance that I have up here, would basically allow parties' unilateral and bilateral conduct to supersede the law and bind courts. That view puts parties at the apex of power, within the law in the middle and courts at the bottom. So how might this world look? Let me give you a little example. Say that the law prescribes a limitations period on a particular claim of 4 years, okay? The parties, they decide that that's too long. That they instead would like a 2-year limitations period to govern any claim between them. And so they agree to a 2-year limitations period by private contract. The plaintiff files in 3 years, and the defendant moves to dismiss, claiming that the claim is untimely. What should the court do? Well, under the model of party dominance, the parties' agreement, the parties' 2-year limitations period, privately negotiated, controls. The claim is untimely, and therefore the court must grant the motion to dismiss. Now, parties can exercise or attempt to exercise dominance over courts unilaterally too. So say instead of filing 3 years into it, the plaintiff files 20 years after the claim is accrued. Okay, it's clearly untimely under any conception of the limitations period. But say that the defendant decides not to move to dismiss on that basis. What can the court do? Well, under the model of party dominance, the defendant's choice to waive or forfeit that defense then disables the court from raising it on its own. I think no one really subscribes to an unadulterated view of party dominance. There are too many other ancillary doctrines like subject matter jurisdiction that we all have come to understand is beyond the control of the parties. But the principle of party dominance exists and maybe even is common in a less absolutist form. In a host of areas, federal courts routinely enforce pre-litigation ex ante party agreements that otherwise would change the law or the procedures that would govern their dispute. And courts are very reluctant to override party conduct during the litigation, such as waiver, forfeiture, consent, and stipulation. There's a broad commitment to party dominance that's pockmarked by exceptions like subject matter jurisdiction. And indeed, one option for the court in Atlantic Marine was an option that had been endorsed by the lower courts, many lower courts, was to consider the party's restrictive forum selection clause as essentially rendering the otherwise proper venue improper under the law. So there's another view, which is the model of party subordinates. And under this model, the parties are at the bottom, with the courts in the middle and the law on top. And here, parties are beholden to both law and courts. They cannot do what the law forbids, and their attempts to alter the law are void. Further, the parties can't control the courts either through their ex post litigation conduct. So even when the law allows parties to waive, forfeit certain issues, that may disable the parties from raising those issues, but the court is free to disregard or override that party conduct and consider the issues anyway. The party choice is enforceable at the discretion, at the superior power of the court. So how might this model play out? Let's take the same example, a 4-year legal limitations period, a 2-year contractual limitations period, and the suit filed 3 years. Okay? Under the model of party subordinates, the party's agreement of 2 years doesn't control anything. The suit is timely under the law, and so a motion to dismiss filed by the defendant would have to be dismissed. Take a different example. Say instead the limitations period is 2 years, and the parties agree to a contract of 4 years. They decide that legal limitations period is too short, and they want to expand it. If the plaintiff files in 3 and the defendant moves to dismiss, what then? Well, the party's contract is irrelevant. The claim is untimely, and so the defendant's motion to dismiss must be granted at that point. Now, in each case, in each hypothetical, one party may have a breach of contract action against the other for failure to abide by the terms of the agreement. But the point is that the agreement doesn't control this litigation. It doesn't bind the court. Now, one additional wrinkle, same slide, but here let's say the defendant decides not to file a motion to dismiss, and instead the defendant decides to waive that right. What happens? Well, 3 steps here. The first is the suit is still untimely as a matter of law. The party's agreement to extend the limitations period doesn't change that. The second step is the defendant's choice to waive the right to dismiss on that ground is not binding on the court. The court could, in fact, raise the untimeliness of the claim and dismiss the case, even basically overriding the defendant's waiver. But the third step is whether the court should exercise its discretion to do that. And here I think the answer is probably not. Why? Because the parties have agreed to a longer limitations period. In other words, they've agreed not to move to dismiss if the claim is filed within the contractual limitations period. And the defendant has abided by that agreement. So it would have to be a confluence of other extraordinary factors, I think, to allow a court to override the defendant's waiver in that context. One corollary of the model of party subordinates is that the law is on top. Okay? The law is supreme. And so as a result, the law could allow itself to be influenced by party agreement or party conduct, and it could force courts to defer to that party agreement or party conduct. The idea is not that the parties would control anything, rather the idea is that the law is supreme and what the law says goes. So a good example of this is the Federal Arbitration Act, okay, which essentially elevates the ability of parties to contractually agree to arbitration in a way that then becomes binding on the court, and the statute has made it so. And Section 4 of the Federal Arbitration Act effectively prescribes a rigorous procedure for how the court will enforce those kinds of private agreements. So with that in mind, let me turn to Atlantic Marine. In my view, the opinion adheres generally to the model of party subordinates with some divergences. Importantly, it rejects the party dominance position that a restrictive forum selection clause, private agreement to say what the venue is, doesn't render an otherwise proper venue improper. And as the court put it, When venue is challenged, the court must determine whether the case falls within one of the three categories set out in Section 1391, which is the venue statute. If it does, venue is proper. If it doesn't, venue is improper. Whether the parties entered into a contract containing a forum selection clause has no bearing. This is a core feature of party subordinates. Parties can't change the law of venue. The opinion also accepts party dominance. The law can incorporate party choice. The court interpreted the venue statute, the venue transfer statute, which is 1404A, to in fact incorporate party agreements about venue. It interpreted the language for the convenience of the parties as essentially being dispositive, or the forum selection clause as essentially being dispositive on the conveniences of the parties. So these features of the opinion support a model of party subordinates. But the opinion as a whole is a bit ambivalent. For one, the interpretation of 1404A, incorporating forum selection clauses under the rubric of conveniences of the parties, is so stretched to approach a model of party dominance in which essentially the parties' agreement replaces the language of the statute. One can easily imagine a host of situations in which a forum selection clause negotiated perhaps years earlier and perhaps not even negotiated at all is not reflective of the conveniences of the parties at the time of the litigation. The most that can be said about this language in the statute, the convenience of the parties, is that it can be informed by the presence of a forum selection clause, but that the forum selection clause ought not be dispositive of that issue. Further, elsewhere in 1404, Congress knew how to incorporate party choice when it wanted to, and did so explicitly by saying that it could be transferred to a venue where all parties have consented. And this is a far more tenable construction of the statute of law's incorporation of party choice than the conveniences of the parties. Another factor that creates ambivalence is that the court made an odd decision to alter its usual Erie rules for venue transfer pursuant to a forum selection clause. And it incorporates the same Erie rule that would be used if the forum were an improper venue. And that, again, is a reflection of what might be if the court adopted a theory of party dominance. So it remains to be seen whether Atlantic Marine presages a broader support for the model of party subordinates, or whether it's meaning to create a small exception for venue to an otherwise broader commitment to party dominance. At the very least, however, Atlantic Marine affects venue in other ways, and I want to talk about just one here. The particular forum selection clause at issue in Atlantic Marine was restrictive. In other words, it attempted to make a proper venue improper. But forum selection clauses can also be permissive. They can attempt to make an improper venue proper. Well, if restrictive forum selection clauses do not change venue law, then permissive forum selection clauses ought not change venue law too. Section 1391, which sets out in great detail the number and the type of venues that are proper, no more allow parties to broaden the scope of permissible venues than it allows them to restrict the scope. And thus, permissive forum selection clauses are just as ineffective as restrictive ones. Now, it's true that the procedural law permits parties to waive or forfeit their venue objections, thereby essentially allowing a case to be heard in an improper venue. But the law affords parties this choice through a very specific mechanism in Rule 12. Rule 12b3 gives parties the right to move to dismiss for improper venue. But 12h1 says that that right is waived if it's not asserted in the first responsive pleading, either an answer or a motion. Therefore, parties can waive this right, but only through the specific mechanism established in Rule 12. A permissive forum selection clause, then, is merely a promise by both parties to use the mechanism established in Rule 12 to waive objections to improper venue. Failure to abide by that promise may give rise to a breach of contract action and a separate action under state law, but it does not somehow make the improper venue proper or deprive the defendant of her ability to use the mechanism 12b3 established in Rule 12. Now, of course, the law could allow parties to waive their objections to venue in advance, but Rule 12h1 doesn't do that. It doesn't say 12b3 is waived if not asserted in the first motion or in the answer or if it's been waived in advance through an ex ante agreement. Besides 1404A, no other venue law or rule allows parties to do so in advance. Perhaps some common law principle, some federal common law principle might extend to permissive forum selection clauses, but that would be a complicated analysis indeed, especially for the kind of diversity cases that was at issue in Atlantic Marine. Perhaps the next panel can educate me on this, though. So Atlantic Marine thus calls into question the enforceability of permissive forum selection clauses too. With that, I'll stop and learn from others. Thank you.
So I would also like to thank the conference organizers and Hastings for hosting this. The inspiration for this paper came as soon as I read the Atlantic Marine decision, and I thought, oh, how very curious. The court is telling me that 1404 and forum nonconvenience are essentially the same thing. Which I had always assumed not to be true. Certainly when I teach transfer of venue and forum nonconvenience, one of the things that I stress to my students is that they're similar but not the same thing. So I wondered, would this case have an effect on how forum nonconvenience cases are handled going forward? And my conclusion, having looked sort of more carefully at the opinion and also at the law of forum nonconvenience in 1404A, is that it's almost even a little bit worse than that, right? Which is that it's going to very much have an effect on forum nonconvenience, but also, strangely, I think, has altered 1404 itself in a way that I don't think is particularly helpful to transfer of venue. So what I'd like to do is talk about how Atlantic Marine is really the culmination of a very interesting story in which the Supreme Court backed itself into a corner doctrinally and then couldn't find its way out in a satisfactory manner. And what do I mean by this? Well, if you think back to the history of forum selection clauses and how they've been enforced in the federal courts, you have two paths that were going on for enforcement. And the first cases came in situations in which the federal courts had jurisdiction by virtue of federal question. And in these two cases, it was actually admiralty. So it was federal law that was being applied in Bremen and in Carnival Cruise. And in those cases, the court announced, whether we like this or not, a fairly strong rule about enforcing forum selection clauses. But then things became problematic when we had to figure out, well, what was a court to do in a case in which the basis for the cause of action was state law, and the claim was in federal court by virtue of diversity jurisdiction? And the way the court found its way out of this was by using the transfer of venue statute. And my argument here is why? Well, because of Erie and Hannah, right, the best strategy for them was to hook themselves onto a statute, right? That was the most easy way to defeat any competing state law claims about whether or not a forum selection clause would be enforced. And that's how, that was sort of the story of hitching transfer of venue to forum selection clauses, right? Time goes on, finally we get to Atlantic Marine, and we have a different problem that resulted in the circuit split. And that was namely that we had to figure out, well, what is the proper mechanism for enforcing a forum selection clause? Because, of course, it turns out it doesn't just have to be 1404. There were these other possibilities out there. And I actually agree with Scott, I think, and possibly disagree a little bit with Stephen about whether the court got this right, whether or not we should have some other mechanism for enforcing forum selection clauses in terms of looking at 12b3 and 12b-6. But this created a problem for the court, which was a gap, right? If 1404 is, in fact, the way to enforce forum selection clauses when the venue is otherwise proper, well, now we have a gap, right? Because 1404A only works for transfers within the federal system. And so the court solves this basically by saying, well, that's okay. In addition to 1404A, we have forum nonconvenience for the situations where the forum selection clause points to a foreign forum or a state forum, and there's really no gap at all because 1404A and forum nonconvenience are the same thing. Right? And in the paper, I give a little bit more detail about why I think the court really is saying that they're pretty much the same thing and not just saying that they're kind of equivalent or functionally equivalent. So we have that collision course there. And then the question is, are they really the same thing? And the answer is no, right? We get this language in the opinion about how 1404A is a mere codification of forum nonconvenience, that they address the same factors. And that's really just not true. If you look back into the history, what you see is that, first of all, the whole timing of the passage of 1404A really has some retroactive legislative history, as one scholar has put it, in that forum nonconvenience doctrine in its modern form wasn't even totally in place yet at the point that 1404A was drafted and then later passed. So the idea that there was this complete law of forum nonconvenience and it was just codified for transfer purposes, that's a somewhat dubious claim. But also, there are good reasons why transfer of venue and dismissal for forum nonconvenience are not the same thing and should not be the same thing. So one of the things that I do in the paper is that I go through, just as a general matter, right, not looking at forum selection clauses, but looking at everything, do we want to be starting a jurisprudence in which the court is essentially saying that the standards under forum nonconvenience and 1404A are the same thing? But I think the answer is no, and the passage of 1404A itself is one piece of evidence for that. Right? The whole reason, in some ways, that Congress decided to pass a transfer of venue statute is that forum nonconvenience is a rather clunky instrument for getting a case from one venue into another venue. And it's clunky for a reason. Right? The reason is that if a case is dismissed, that's a pretty drastic remedy. Right? And once a court lets a case go into another venue, into another forum entirely, a foreign forum or even a state court forum, the court lets go of a lot of its ability to control what's going to happen in the outcome of that litigation. Now, courts have tried to sort of shore up that aspect of forum nonconvenience by making many of those dismissals conditional. And in the paper, I talk about the fact that even if that's true, it's still the case that because the mechanism is different and because the remedy is different, it doesn't make sense to equate these two doctrines, right? It's not consistent with jurisprudence over the last 60 or 70 years, and it's not particularly good as a policy matter to equate these two. One response you could make at this point is to say, well, maybe this is just something that's bothering me personally, right? They've equated forum nonconvenience and 1404A, but it's just in this one case, and it's about forum selection clauses, so it's not going to sort of go into broader things, right? And I have two responses to that. One, I don't trust the court to contain this to a particular area. And the reason can be summed up in two words, Twombly and Iqbal, right? After Twombly, there's, it's this very broad holding, but it's just about antitrust cases. And it's just about these really, really big, large class actions. Surely, the court will kind of come to terms with that and can contain the holding. We all know that that's not true. So I am not willing to rely on the fact that this case is about forum selection clauses to as a bulwark against the creep of 1404A into forum nonconvenience, which I see as problematic. But beyond that, I think that even in the context of forum selection clauses, it's problematic to equate 1404A and forum nonconvenience. And the reason is that in order to make 1404A work in this case, the court basically transforms 1404A into this solid, rigid, non-discretionary doctrine, which is, first of all, I think that's just a poor interpretation and application of 1404A. But I think to the extent that that's bad for 1404A, it's even worse for forum nonconvenience. So let me take you through how I think the court has done this. And when the court decides that it's, 1404A is the proper mechanism, and now we have to move on to the question about whether or not to actually enforce the clause, the court makes several interesting moves that we've already heard about so far. Right? So one of them is to say, 1404A, which is a discretionary standard, theoretically looks at both private and public interests. Well, we get a little bit of a surprise in the opinion. The first one is that you don't look at the private interests at all, right? So half the interests are just gone right off the bat. Then we get to the public interest factors, and the court makes this interesting choice of law decision that has to do with Erie, where they say, well, normally the law follows you from the transferor court to the transferee court, but for forum selection cases, that's not true. And the effect that this has on 1404A is to say that often the fact that there might be choice of law issues and applicable law issues in the transferee forum, that's a public factor reason for considering whether or not transfer is a good idea. But the court has effectively taken that away, right? So that public factor is gone. So we're left with only one relatively weak public factor left. And so this test, which had been a discretionary test, a multi-factor test, has gone from this bastion of discretion to a very rigid test in which there's only one result allowed, and that result is to enforce the forum selection clause. So as I said, first of all, I think this is a problematic interpretation of 1404A, right? We circle back to this law of unintended consequences. The whole reason the court was able to hitch forum selection clause enforcement to 1404A in the first place was to talk about the federal interest of having a flexible and discretionary law of venue, right? And that was going to trump any sort of state interest in terms of whether there was a collision, Erie-wise. Well, they've just written 1404A so that it reflects nothing of what made it that way in Stewart in the first place. So that's troubling. But also, the implication is that when dealing with forum selection clauses, the question of whether or not to use this test in a discretionary way has gone away completely. There's only one possible answer. And forum nonconvenience, I think, even more so than 1404A, is a situation in which we want federal judges to be able to fashion results that involve the exercise of discretion, right? For one thing, that sort of discretion is what allows judges to have these more creative remedies in terms of conditional dismissals, right? And I think there could be a real question about whether some of these conditional dismissals are actually enforcing the forum selection clause in that way. But also because particularly in the international context in which there is a worry on the one hand about comity and respecting other countries, but also about the law that might be applied when a case goes to a foreign forum. I think that there are much further concerns about whether or not a forum selection clause is in fact the right thing to be applied in a particular case, right? In taking this discretionary doctrine, equating it to 1404A, which apparently is now non-discretionary, and making it non-discretionary, I think is not a particularly good idea for forum selection clauses. So just to conclude, my thesis here is that this conflation happened, right? It's bad in general for the law of forum nonconveniens. And even with forum selection clauses where you might say, well, we should just enforce them all anyway, I think even in that situation, this sort of confusion and conflation is problematic. So with that, I will let us hear from our last speaker on the panel.
Thank you, and a special thank you also to Scott Dodson, to the Hastings Law Journal, and to Hastings College of the Law for inviting us. It's wonderful to see this symposium actually taking place after it having been just sort of a germ of an idea. I'm going to conclude this panel by just identifying 5 areas where, notwithstanding all the things that the court actually did in Atlantic Marine, the court has actually left some very, very significant questions open. Atlantic Marine dealt with a relatively simple scenario. You had 2 parties, they were both businesses, they were both trustworthy, they read their contracts, these were big kids, we could trust them to do what they were going to do, and they had both agreed that they were going to sue each other, if at all, in Virginia. Lo and behold, something goes wrong and one sues the other in Texas, which is not in Virginia. This was a problem. And so the question is, what do you do? Because there's perfectly good personal jurisdiction in Texas, perfectly good venue in Texas, according to the venue statutes. So how do you get the case out of Texas? And the court settled on 1404, the venue transfer statute, as the primary remedy for moving a case from one federal court to another using a forum selection clause. Now, it so happened that an amicus to the court wrote in silver-tongued hues of the viability of other ways of dealing with that, which the court dropped like a hot rock and did not discuss. I'd be happy to talk at length about the virtues of other remedies for forum selection clauses, but I will spare you that for the moment. What I want to start with is to identify the questions that the court did leave open. The first is, are there other remedies, such as 12b6, such as Rule 56, and what do you do if there are multiple remedies at the same time, not just 1404? Second question. The court assumed, because the parties before it had litigated that way, that the clause in question was valid and enforceable. Well, what actually determines whether a law is valid and enforceable? Is it state law? Is it federal law? We'll hear more about this in the second panel. Third question. What if, after applying whatever law it is that decides these things, we determine that, in fact, the clause is not valid? What do you do with it? Is it just as of nothing? Does it have some weight in the analysis? What do you do? Fourth question. What happens if there are multiple claims or multiple parties in the same case? So I have a contract with one defendant, but I don't have any contract with the second defendant, and both of them caused my injury. I sue them in the same case. I can do that. Rule 20 is very liberal about that. But what does the court do with the action now that it's before it? And finally, what do the court's new standards for forum selection and enforcement do for taking cases up on appeal? So in the hopes of getting quickly to the back and forth interchange between the panelists and your questions, I'll try and not use all of my time, but I want to deal with these 5 questions. First, what do you do when there are multiple different kinds of remedies on the table? So let's say, for instance, that you could either transfer the case from Texas over to Virginia or get it dismissed. This makes a big difference, because if you can dismiss the case, you can invoke the statute of limitations, or SOL. So you can say, look, on the day you filed, you are within the SOL period, but let's say we've been litigating about venue for a long time, and now, as of the point where we might dismiss it, the limitations period has lapsed. So if you try and refile in Virginia, you're going to be, as I tell my students, in the technical term, SOL. The problem here is that that's a very significant sanction for a plaintiff who might have thought in good faith that they could sue in Texas. And you know, one of the reasons why people resist the idea of dismissal as a sanction is that it could leave people high and dry. Court said, in the context of forum nonconveniens, you know, that's just fine. That's your problem for signing a forum selection clause. But as we all know, you know, everybody signs forum selection clauses, so we might think that too harsh. On the other hand, what do you do with the person who serially litigates in different places? Let's say they file in Texas. They get a 1404 saying, no, you've got to transfer somewhere else. They try and voluntarily dismiss. Then they file somewhere else that also isn't Virginia. You might think eventually that we want to cancel this out to say, hey, you sued in the wrong place, you go home. You can do that when venue is improper under 1406, and part of the question is, can you do that under enforcing a forum selection clause? Second question, what law governs the enforceability of forum selection clauses, state or federal? I'm not going to say too much about this because it will be discussed at greater length in the second panel, but I want to say that there are actually really good arguments on either side. So on one hand, for state law, forum selection clauses show up in contracts. Contract law is state law. Ergo, forum selection clause law should be state law. That's a perfectly sensible argument. There is no general federal law of forum selection that is at least codified anywhere. But then on the flip side, there might be an uncodified federal law of forum selection in the following sense. Imagine that you have a state that says, we will enforce every forum selection clause, no matter how adhesive the contract, no matter how unconscionable. If it says you have to litigate under the sea, that's fine, we'll enforce it. You could imagine a federal court saying, that's great, state of Mississippi, but we don't want to enforce forum selection clauses that way. And if we are sending the cases from one federal court to another federal court, that's our business. That's not something that a state law can control, because no state can transfer cases from one court to another. So it's at least plausible that there might be federal rules on the topic that are not just the application of state law. Third, what do you do if the clause isn't valid? So the last significant case on forum selection the court had, a case called Stewart Org versus Rico Corp. They said very explicitly, we don't care whether a clause is valid or not when we're going to transfer under 1404. 1404 is an all things considered inquiry. If you've got a forum selection clause, we just throw that in the pot with all the other factors and make our decision accordingly. And whether it's technically valid under whatever source of law governs here doesn't really matter to us. If you signed it and if it wasn't the result of overweening bargaining power, then it's fair to move it in such and such a fashion. And that's all we care about, because 1404 is all about fairness. That is not what the Supreme Court did in Atlantic Marine. In Atlantic Marine, they said, if it's valid, you get very strong thumb on the scale in favor of transfer, and if it's not valid, we won't tell you what we're going to do. Well, there are going to be cases where the forum selection clause isn't valid, and lower courts will need to figure out what to do with them. Do they give them the sort of somewhat heightened thumb on the scale that they got in Stewart? Do they treat them as if they were nothing at all? It's not clear. In particular, this is hard because of what the court did with respect to choice of law that other panelists have mentioned. So it used to be that 1404 transfer left choice of law intact in cases called Van Dusen and Ferens. And one of the holdings of Atlantic Marine was that they were throwing Van Dusen and Ferens under the bus for the purpose of forum selection clauses, and saying when you get to the new forum, we start over with a new choice of law. That's great, but the problem with it is, what if you want to transfer a case? What if there are excellent reasons to transfer a case, but you're not sure if the forum selection clause is valid or even what law determines that? Under the old regime, you just transfer the case because you've got 1,000 different reasons to transfer it, and 1404 transfer is clearly justified. Now, the district judge has to actually figure out, okay, am I transferring this just because the case ought to be transferred? Or am I transferring it because it ought to be transferred and they have a valid forum selection clause, in which case it changes the law that will apply in the new forum? That's a problem that the court has not yet encountered. Fourth question. What do you do with multiple claims? Multiple parties. Some of them are covered by the forum selection clause, some of them are not. If you had a remedy that was directed to each individual claim, such as 12b-6 or Rule 56 or something like an affirmative, if you had one of those wonderful remedies that we can talk about later, then you could just deal with each individual clause on its own merits. I've got a forum selection clause that attaches to claims 1, 3, and 5 in this complaint. Great, 1, 3, and 5 are dismissed. We'll deal with the rest later. 1404 as a remedy is something that has to be done to the action as a whole. You can't just 1404 away some of the claims and not others. So the courts have to say, okay, what do I do if I have a thumb on the scale in favor of transferring some claims and a thumb on the scale against transferring others, with the choice of law to be different in different places? One option that they can do is sever the different claims under Rule 21, basically break the case into two and send half of it to Virginia and keep the rest in Texas. But whether to sever or not is a discretionary decision, and while the circuit courts haven't really dealt with this yet, there are intra-circuit district splits on what you're supposed to do in that situation. Some courts say, yes, you should sever. Some courts say, no, that's unfair to the plaintiff who got to join all their claims in a single action, and they're really struggling for rules as to what to do here. Finally, the question of what to do on appeal. So let's say that you bring the case in Texas. It ought to go to Virginia, but the district court erroneously says no. What do you do with that? Ordinarily, under 1291, the only way to take an appeal from that is to wait until final judgment, then appeal to the Fifth Circuit from Texas and say, I was harmed by their refusal to transfer it to Virginia because I know I would have won if it had gotten to Virginia. All right, that's really hard. It is very hard to show the case that you lost in Texas, you would have won in Virginia. The other thing you can try to do, the court has said you can't bring it up on collateral order doctrine. You can try to get the district court to certify the issue for appeal, but they might say no. And the only option left is mandamus. To get mandamus, which is immediate review by the Court of Appeals, you need to show that you had a clear and indisputable right to relief and that there was no other adequate alternative remedy. Atlantic Marine changes the mandamus inquiry in two different directions at the same time. So on the one hand, by putting a huge thumb on the scale in favor of transfer, they make it real easy to argue, I have a clear and indisputable argument for transfer to Virginia. Circuit court, please save me. Get this case out of Texas. On the other hand, because of what they do to choice of law, it makes it a lot harder to argue, I have no adequate alternative remedy. Because the circuit court could very well say, look, wait until final judgment. If the court had sent you to Virginia, you would be governed by Virginia choice of law rules, which all else being equal probably select Virginia law, in which case you might actually have gotten a different result. That means there was error that is not harmless. Any harmless errors we'll disregard, but that kind of error actually hurt you, and that we will overturn on appeal. So, because we know we will overturn it on appeal 2 years from now, you have to struggle for the next 2 years in this court. You have an adequate alternative remedy. Now, that might not sound very adequate to people, but in fact, in a case called Lauro Lines from the 80s, the Supreme Court said it was adequate. So it would seem that mandamus is almost entirely foreclosed as a remedy by anyone who's actually hurt by a district court's refusal to transfer, which is weird because it means that the people who have the most to lose from the refusal to transfer are the only people who are denied mandamus, and everybody else gets to get it immediately. I don't know that that's how the circuit courts will actually cash things out when this gets there. They're normally more sensible than to follow the law like that. But it hasn't, to my knowledge, posed that question yet, and I'm sure that it will. So in summary, the Supreme Court did what it thought was a very sensible approach to what seemed like a very simple case, but by doing so, it opened up a whole can of worms, and that is a can that the circuit courts and the district courts will have to labor to close, worms notwithstanding. Thank you.
Well, you can see what an incredible panel we have, and the fact, having moderated many panels over more than 30 years in the profession, that they all kept time so that we have a lot of time, which is great for us to continue this discussion and to further out some of the ideas that are put forward. So two things. I will start by asking the panelists if they have anything they want to say to one another or questions that they want to ask, but I would encourage you, there is a microphone in the center of the room, and it would be most helpful if any of you who have questions or comments, if you'd use the microphone to do so. So if you want to start kind of getting up there just for so people are around, that would be a great thing too. So let me start it off with whomever. Is there somebody that would like to follow up on something?
I have a comment, which is that this was a unanimous opinion, and yet all of us on the panel found some very serious issues with the opinion itself. In particular, we all agree that 1404A, at least the way the court used it and interpreted it, is very problematic. It's a clunky way, at least the way the court did it, it's a clunky way to incorporate enforcement of forum selection clauses. And we all agree that the court created a very odd bifurcated choice of law system where a 1404A transfer based on a forum selection clause has different choice of law implications than a 1404A transfer without a forum selection clause. So I just wanted to point that out. I'm not sure what the court was thinking, but maybe it's that the court doesn't think about civil procedure that much. And Justice Breyer is right that he can't remember his civil procedure class at all. That's one comment I had.
All right. Response or some other comments?
I was going to say that I don't think it's quite so bad in terms of remembering civil procedure. I think the problem more was one of adequate briefing, in the sense that, my brief didn't address the 1404 question, sort of what should the standard be. The respondent's brief, labored mightily on the question, but certainly I think that had more civil procedure scholars come in, there might have been more of a sense of what the dangers were on the other side. And in particular, as far to my knowledge, and this may be incorrect, but to my knowledge, no one in the entire procedural history of the case breathed a word about changing the choice of law standard until Justice Ginsburg suggested it in the middle of oral argument. So maybe this is a comment on the dangers of judicial creativity, certainly at least as compared to the issues that are briefed.
I think it's also a comment to our civil procedure students who are out there in the audience that, see, civil procedure can rule the world, so be careful, study your stuff, because then you'll be ahead of everybody and you'll inform the Supreme Court when you get up there about what they should be paying attention to.
So I want to comment on this as well. I actually end my paper with exactly this question, which is, why was this a unanimous opinion? I couldn't figure it out. I could imagine a situation in which they might have all concurred in the judgment, because I think that's what happened, is that they all agreed on the outcome. But it is just puzzling to me that they all signed on to basically rewriting 1404, this very strict enforcement of forum selection clauses. And I think it's true that they might have been asleep at the wheel a little bit, and we might have been. And one of the things that I suggest is that this case was seen as the lesser important civil procedure case of the term. That everyone, and this is tremendous props to Professor Sachs, who wrote an amicus brief and was focused on it. I was like everyone else, which is that I was watching Daimler, I was watching Walden, the not civil procedure part of me got all upset about Hobby Lobby and all those other things that were going on, and that and a case like this really snuck in under the radar. And I think it is a call for all of us to pay attention, not just to the cases when they come out, but to have a more active role in the briefing and watching how these cases percolate up from the district court to the Supreme Court, because otherwise we can be surprised with opinions like this.
Brad, do you want to add anything?
No, I
Okay.
pretty much agree.
Okay. Rick?
Rick Marcus, Hastings. I get to ask my panelists questions the second panel, but what's come up now causes me to ask the first panel a similar question, and it has two parts. Number one is, I gather from what I'm hearing that you'd all be a lot happier if the Supreme Court never took a civil procedure case. Second part, I gather that if it continues to do so, you think it will listen to civil procedure professors. Professor Sachs, no doubt, should be viewed very differently now than he was when he was a law clerk to the Chief Justice a few years ago. So I guess it's a sort of a question I ask myself, which is, where's our humility in all of this? But my basic question is, has the Supreme Court really made things a lot worse, even if it's forgotten what it covered in the first year? And if so, should it simply stop?
Well,
Thank you, Rick.
maybe I'll let Professor Effron know. I think the Supreme Court's they're not academics. They're looking for a workable solution, and as far as it goes,
Which is not what academics do, right?
correct. And as far as it goes, I think Atlantic Marine is at least a workable solution to it. I think that the Supreme Court has made some good headway on certain civil procedure decisions in recent memory, particularly the jurisdiction ones. but it has created some very odd other opinions, such as Twombly and Iqbal, that have, they go to Professor Marcus's point that maybe it should watch what it's doing a little bit more closely.
Anybody else?
The only thing I was going to add is that I'm not entirely sure that the Supreme Court is focused on workable solutions. Sometimes they might actually be sacrificing workable solutions for the law, in the sense that most of the circuit courts had said this is a venue problem. Most of them had said 12b-3. For all I know, 12b-3 is probably the most workable way of dealing with all this stuff. But the court, I think, correctly rejected that, saying, look, that's not what the venue statutes say. What the fallback was a question, but at least it did not make that error.
And if the Supreme Court stopped taking these cases, then we'd all be out of business. So I'm all for them taking these cases. Yeah, I'll stop there.
Bill?
Bill Dodge, UC Hastings. This question is asked out of ignorance, which is, so if 1404 doesn't apply and it's a forum non-motion, which of the 12B options does the court dismiss under? I would have thought 12B3, but that's in some tension with this. And I've got a second, somewhat related question, which is really, the court's treatment of Professor Sachs' brief really sort of boggles my mind on reflection, because if the right answer is to dismiss for 12b-6, the court shouldn't consider itself foreclosed from deciding that that's the case by the party's choice not to file such a motion. I mean, if the court may have made some bad law because of the parties in this case's pleading decisions, and the proper response, if the court thought that was right, well, it could have asked for more briefing if it didn't feel it had enough briefing on that point. But the court could just have said, the proper remedy would be 12b-6, but you didn't make such a motion, so you lose in this case. But the court didn't have to feel that it itself was constrained from pursuing that option if it thought that was the right option. So I guess those are two questions.
So the first question being, what is 12b-3 work for Form Non? What works for Form Non in that circumstance? And I think, Bradley, I mean, you talked about the fact in your paper about the way 12 operates. Do you want to say something in response to that?
Yeah, well, now it works. My answer would be none of the above. I mean, I don't think 12b is the answer. And just to elaborate, I would just say that I think people have to get off the idea that every procedural defense, dispositive motion has to be run through 12b or has to be named in the rules. I think there can exist forms of dismissal of a procedural nature that don't fall in any of those categories, and I think this is one of them.
And actually, I will add to that, Bill, that there are a lot of lower court cases, not necessarily on Form Non, in which 12b is called an undifferentiated 12b motion. It doesn't fit under any of the categories, but courts recognize they have the power to use 12b as a generalized motion to dismiss on whatever the ground is that makes some sense.
Well, I would just add, too, there's some people that think that there's been things written about whether we should amend the rules or this or that to incorporate like forum selection clauses, and I would be against that, too, because once you go down that road, then you're going to have to account for every possible conceivable dismissal that might be floating around out there. And that just seems like a losing proposition to me.
Okay, what about the second, Bill's second point?
I think that the reason, I mean, I'm speculating, of course, the reason why the court didn't want to discuss the idea of forum selection as an affirmative defense or under 12b-6 or anything like that was largely the parties' briefing choices. But I think that that's not such a bad rationale in the main for the court, because it's dangerous when the Supreme Court says something that the parties haven't fully exhausted. I mean, look at what we're talking about here with the Van Dusen and Ferencz change to the choice of law. You don't know what all the consequences of that will be. You need things to be fully aired by the courts below, by the parties in briefing, by amici. And while I think that it would have been within their capacity to read what the First and Third Circuits had said and see whether they agreed with it, there are excellent reasons to be cautious in doing that. Now, maybe in the end, by being cautious there, they were foolhardy elsewhere. But I can certainly understand why the court I think the court ought to ask for supplemental briefing much more often than it does, but given that it doesn't do that all that often, it's not crazy that they would be leery of an argument that the parties hadn't fully aired.
Thank you. I have a response on point to make on the forum non question, which I think is that Professor Shannon and I disagree about a lot of stuff on this, but I think we're in agreement here that you don't need a 12B motion for forum non because it's an inherent power that the court has to dismiss a case under forum non. I don't think you need an explicit rule for a dismissal motion under forum non.
Yeah, and in fact, I would just add one thing to that, which is that a lot of the conditional dismissals that are made under forum non would work very uncomfortably with 12B, which is why a lot of district courts, and sometimes weirdly they're made under summary judgment. I don't know if they're actually made under 56 or if a district court is just using the words summary judgment as a basis for forum non. But it's one of the inherent powers, and it's because the remedy is so flexible.
I mean, it may depend, I'm sorry to jump in, but it may depend on whether we think of forum non as a defense, because there's the catch-all at the beginning of Rule 12, which is all defenses have to be pled in the answer, but for these 7 that you can raise by motion. So it depends on whether we think there are sort of implicit exceptions to that, like, I don't know, motion to dismiss for failure to prosecute or something like that. That might count.
I don't think it's a defense. Does anyone else think it's a defense?
There you go. Yes.
Kevin Claremont from Cornell. I got a lot out of all 4 presentations, but this question is really for Professor Sachs. It's something that came to me that I didn't get from reading your paper, but I largely got it because Rick Marcus whispered it in my ear during the talk. You say that you make the transferor court transfers under 1404. Well, it could be transferring because there's a proper forum selection agreement, or it could be transferring just under 1404 generally. And that has a big effect on what law will apply, right? That, I mean, if you transfer under by a forum selection clause, you'll be applying transferee law. So it gets to the transferee court. Does the transferee court then have to decide, was this a forum selection agreement transfer or a non-forum selection agreement transfer? I guess this would have to be one where you're in a proper court under the venue statutes. There's a forum selection clause. There's a transfer. If it is the transferee court deciding enforceability, what law does it apply? If it's well, I mean, that's a bit of a puzzler, isn't it? So what were you thinking about when you said there that you're going to have to decide what the transfer, what's motivating the transfer?
Right. So my initial picture was that the transferor court would hopefully say what it was doing, but if it doesn't, then we've got even more problems.
Yeah,
because you've got to say, okay, am I trying to assess whether the transferor court should have, although sotto voce, transferred it in this flavor of transfer or that flavor of transfer? And if I'm wrong about that, appeal only lies to my circuit court. So you can have some very strange consequences there.
Well, particularly if the transferor and transferee law have different enforceability of forum selection agreements.
And what if the and another question is, do we care what the transferor court said? Suppose the transferor court said the wrong thing. Can the transferee court say, this isn't just a regular 1404 transfer, this is an enforceable forum selection clause transfer, even the way that even under the transferor court's law? I have no idea what they're going to do with that. But
okay,
someone's
that was a big question. That's good.
Someone's going to have to figure that out, not me.
Yeah.
But I think also it really shows how far the court has gone from their statement in Stewart v. Rico that 1404A is, quote, a mere housekeeping statute, right? The more you inflect 1404A so that it's doing all of this substantive law work, the less credible a case you have that it is supposed to be, and of course in my mind, distinguished from things like forum nonconvenience by being just about managing, judging, and housekeeping, and just sort of taking the case and transplanting it to another court that will be more or less just like it, but retain all the features of the original case.
Thank you.
Just to complicate that a little bit, most contracts that have a forum selection clause also have a choice of law clause. So if it's transferred according to the forum selection clause, but the contract also has a choice of law clause that points to a particular jurisdiction, then what?
Yes.
Hey guys, this is a great panel. I'm Adam Steinman from Alabama, and I'm going to get kind of in the weeds here, but you know, I'm a civil procedure person, and there's a reason I'm here and not lined up outside the Apple store for my iPhone 6 right now. So my question, I guess, starts off with an observation that that Brad made about, you know, 1404A is tricky to use if the destination district is not a proper venue under 1391. And I guess I was wondering what your thoughts were on that new end of the clause language in 1404A about transferring it to a district to which all parties have consented. Could you use that potentially to get around that problem? And then that sort of made me think about one of Scott's observations, which was about permissive permissive form selection clauses. So you file it in a district that is not proper under 1391. We accept the idea that a form selection clause doesn't make a venue wrong. It also doesn't make one right. Could you essentially have that district transfer it to itself using that last clause in 1404A? Transfer it to a district to which all parties have consented, and that happens to be its own district. So that's one question. Then I'll just throw out one sort of comment for Steve, which is, I think it's a great point you make about how it can be problematic for choice of law purposes if we don't know what the basis is for the 1404A transfer. And my only thought, and I don't know the answer to this, has this ever arisen in the pre-Atlantic Marine line between 1404 and 1406? Right, we could have a case where a party comes in and says there's no jurisdiction, there's no venue, and you should transfer it for all the convenience reasons under 1404A. You could have a similar problem where the destination forum doesn't know what choice of law one to use.
There is such a case, Martin versus Stokes. Martin versus the Sixth Circuit, and they said that the transfer court could make it.
They get to decide. So that would suggest the kind of post hoc, we just figure out what they were doing. So I'll just, you know, stop there. Let you guys talk.
Well, I can deal with the 1404 thing. Yes, the recent amendments to the section 1404, just a couple years ago, they added the language that you can transfer it to a district to which the parties have consented. And then the issue becomes, does that relate to pre-commencement consent, post-commencement consent, or both? And the court the opinion can certainly be read that they were reading it as including pre-consent or pre-litigation consent. In other words, to encompass forum selection clauses. But after doing some digging, I think from a statutory interpretation standpoint, that argument, it doesn't apply. In other words, that when they amended the statute, when they said consent, they were talking only about post-commencement consent. Because it's really hard to read the statute as encompassing pre-commencement consent. So I'm pretty confident about that, despite the court's language. But I went a step further, too, and this wasn't in my paper, is when you have problems with statutory interpretation, it's really hard. You can't really usually go back to Congress and say, well, what did you mean by this? But of course, with this Venue Act was not a normal statute. We pretty much know who wrote it, and I did talk to them. I did talk to the people that my understanding was that actually wrote, at least initially, before it went to Congress, that provision. And I asked them, well, what did you mean? Or what were you thinking? And the two people I talked to, this was just all in emails. First of all, it was pretty clear to me that they did not think of this problem when they wrote that provision. I think maybe in retrospect they should have addressed it, but they did not think of this, the forum selection clause situation. And in the end, I think, I don't want to put too many words in their mouth, but I think they agree with my interpretation that it does not apply to pre-commencement forum selection clauses.
One other point there, and I don't mean to jump back in, but I might actually push back gently on some of the claims that Scott made about the pre-dispute venue waivers or jurisdictional waivers, and are those really enforceable? I think it's not entirely implausible that there is uncodified federal common law that allows parties to waive arguments or claims in advance. There is no codified law of remedies that is relevant to federal claims and so on. There's no codified law of settlement or nothing written about when you have waived an argument by failing to preserve it below in the adequate way and how much you have to do on that. So it seems very plausible to me that yes, the law, I agree with you absolutely on the model, the law is always in charge, but it might well be that the law routinely allows parties to waive their venue objections, their personal jurisdiction objections in advance, not just through 12H. And one way of getting at that would be, suppose that you did bring a breach of contract suit. Suppose that you brought it as a counterclaim in that very action. What would it look like, and what would your damages be? Your damages would presumably be, well, everything you lost from them filing an action in a place where they weren't supposed to and they should have lost, and also all your attorney's fees. And it seems like, well, if you're going to win that, then as a set-off, they should just end the case now and specifically order specific performance by saying, okay, you don't get to make that argument, because if you do, every minute that the clock runs is just one more minute that you're going to have to pay the other party back for all their attorney's fees. So it's easier just to sort of cut it off in advance.
Yeah, I tend to agree that would be the easier way to do it, but I just don't see the mechanism for it that we have currently, unless there's some kind of federal common law of enforcement that the court hasn't done a very good job explaining.
This may be why one man's reductio is another's conclusion. This to me just shows the ubiquity of federal common law.
Yes. Oop. You're done? Okay, I didn't know you turned around and you came back. Well, actually, I will follow up with Scott on that. That is, my one thought was, so you said a couple of different occasions, well, in any event, they can bring a breach of contract action. So really, it would be better to have party subordinate approach, because that would have the law be the supreme, and then leave them to breach of contract. But the question is, if so, you have to weigh the costs. I mean, ultimately, in terms of the system, the costs and the benefits, and that partly goes into if you even brought it, even in a separate suit, what essentially you're going to get for breach of contract. Is it that you lost when arguably you would have won if you were in the other jurisdiction? I mean, is that a realistic alternative? As well as, doesn't it sort of just increase the cost of litigation, because now you've got two pieces of litigation rather than one?
Right. I think it's not particularly realistic, because I think to be able to assert a breach of contract action in the same case, seeking a remedy of specific performance, would be quite difficult, particularly if the parties have attempted to alter procedures that wouldn't come up until later in the case. Mm-hmm. And even those that would come up early in the case, you'd have to comply with joinder and jurisdiction rules and all that good stuff to get the breach of contract action into the case anyway, which you might be able to do. But there are additional hurdles to it. So I agree, and you could have a subsequent litigation for breach of contract that seeks damages that would be the difference in whatever the litigation would have looked like had the contract been enforced. But again, those are highly speculative damages, hard to prove. So I think there are many practical difficulties with the breach of contract remedy, even though it might still exist. You might be able to make them more practical by putting in liquidated damages clauses or fixed penalties for a breach of those kinds of arrangements. And in addition, if it's too much, since the law is supreme, the law can always be changed to incorporate party agreements in specific instances that would then become immediately enforceable. It's just up to Congress or the rulemakers to do that. And if the parties are still upset about it, then they can always opt for arbitration and create their own procedures in arbitration. And we have private adjudication models that are out there. I just object to the ability of parties to tinker with the public litigation system too much.
Okay. Are there any other thoughts or questions that people would like to offer? Then I think it's an appropriate time for everyone to thank very much our panelists who have really elaborated enormously.